Imagine standing in a muddy courtyard on a bleak February morning in the year 1198. You have been accused of stealing a silver chalice from the local abbey. There is no courtroom with robed lawyers, no fingerprint powder, and certainly no forensic analyst waiting to testify. Instead, every pair of eyes in the village is fixed on you because within the next few hours, your fate will be decided by one of the most terrifying institutions of the Middle Ages, the ordeal. Whether you burn, drown, bleed, or swing a sword against your accuser, everyone present believes that God himself will reach down and reveal the truth. This is medieval justice, raw, immediate, public, and profoundly spiritual. And for the next half hour, we are going to step inside that world to understand how trial by fire, trial by combat, and the solemn power of the spoken oath decided guilt or innocence. To grasp why these methods seemed reasonable, we have to slip into the medieval mindset. From the 9th to the 13th century, Europe was a quilt of feudal fiefdoms, ambitious kingdoms, and territories under direct church control. Written law codes certainly existed: Charlemagne's capitularies, England's assizes, the growing body of canon law. But literacy was rare, professional police forces were non-existent, and most disputes were resolved locally. Justice rested on two pillars. First, there was an unshakable faith in divine judgment. A just God would never allow the innocent to suffer unjustly. Second, there was communal reputation. Your standing among neighbors mattered more than any document. Together, these beliefs produced a legal culture that felt no contradiction in asking God to rule through flame, water, or steel while an entire village watched. The ordeal, or ordeal in Old English, was literally a judgment. The procedure blended liturgy and spectacle. Priests fasted for days, holy relics were arranged on an altar, psalms were sung, and the accused was ushered into a life-threatening test in full view of friends and foes alike. If you survived, or if your wounds healed clean, God had sent his verdict: you were innocent. If you failed, the sentence was often immediate death, and people departed believing the moral universe remained intact. By modern standards, the ordeal sounds brutal, irrational, even barbaric. Yet to a medieval Christian, it was an act of profound piety. Justice served under the eye of heaven. One of the most common ordeals was trial by fire. Picture a blacksmith's forge carried into the open square, the iron rods glowing a furious orange. In Anglo-Saxon and early Norman England, the accused might be ordered to carry a red-hot bar 3 measured paces. His hand was then bound, sealed with the priest's wax, and inspected 3 days later. A clean, pink wound meant acquittal. Any sign of festering condemned the bearer as a thief or worse. On the continent, particularly in parts of Germany, the theater was even more spectacular. Barefoot suspects paced across 9 red-hot plowshares laid out like stepping stones to salvation. The community gathered, prayed, and accepted whatever outcome the flesh revealed. Horror mingled with reverence, reinforcing the conviction that their world, however harsh, remained under divine governance. If fire tested courage going in, water ordeals punished long after. In the cold water version, a rope-bound defendant was lowered into a pond consecrated by holy water. Because baptism symbolized purity, medieval logic dictated that sanctified water would literally reject the guilty. If the accused floated, or more accurately, bobbed like a buoy bound by rope, the crowd saw instant proof of sin. Should he sink, innocence was affirmed, though drowning posed its own grim irony. The boiling water ordeal offered an equally excruciating path. The suspect plunged a bare hand into a cauldron to fetch a stone or ring from the seething bottom. As with hot iron, priests wrapped the wound and prayed over it. 3 days later, God's bandage check determined the verdict. Across Frankish, Slavic, and Scandinavian lands, these rituals persisted because, occasionally, someone did emerge miraculously unharmed. Such rare survivals kept communal faith alive and prevented the system from collapsing under its own cruelty. More dramatic still was trial by combat, the legal duel romanticized in countless legends, yet deadly in sober fact. Under this procedure, a plaintiff and defendant, or champions hired in their stead, invoked what was called a wager of battle. They pledged before officials and clergy that God would grant victory to the rightful party. Nobles fought on horseback with lances before switching to swords. Commoners battled on foot with clubs or staves. The field was consecrated at dawn, ringed by rope or stakes, and the entire village turned out, eager for the mix of blood sport and jurisprudence. Defeat meant legal guilt and often death. Victory conferred immediate vindication. Even women, clergy, and the elderly could participate by appointing professional champions whose reputations were quite literally worth their weight in gold. The famous 1386 duel between Jean de Carouge and Jacques Legris in Paris, immortalized as France's last state-sanctioned judicial duel, captures both the pageantry and the terror. One man's triumph proved his cause, the other's corpse sealed the verdict, and the crowd dispersed, satisfied that heaven had spoken through sword arms. Not every case, however, ended with burnt hands or broken skulls. Compurgation, or oath-helping, offered a verbal route to acquittal rooted in communal trust. The accused swore innocence upon holy relics, then produced a specified number of oath-helpers, often 12 reputable men, who swore they believed him. No one expected the helpers to know the facts. What mattered was their willingness to stake their souls on the defendant's character. In tight-knit villages, reputation functioned as currency. A chronic drunkard or known brawler might fail to recruit even one supporter. A respected craftsman could line up a dozen neighbors in minutes. Compurgation spared the court the expense of dead bodies and the community the trauma of ordeal, while still satisfying the medieval hunger for public affirmation. Scholars of law see in this custom the earliest seeds of today's character witnesses. By the late 12th century, a quiet revolution stirred. Canon lawyers, steeped in theology and the rediscovered writings of Roman jurists, began to question ordeal's spiritual legitimacy. In 1215, the Fourth Lateran Council, convened by Pope Innocent III, forbade priests from blessing ordeals. Without ecclesiastical endorsement, the fiery and watery judgments withered across Catholic Europe. Secular rulers experimented with sworn inquests, asking 12 local men not to swear belief, but to present evidence, opinions, and rumors, a crucial step toward the modern jury. In England, King Henry II's Assize of Clarendon, 1166, and Assize of Northampton, 1176, solidified the practice, instructing sheriffs to convene such panels for major felonies. On the continent, the revival of Roman civil law encouraged inquisitorial procedure where judges questioned witnesses under oath and recorded written testimony. Yet nostalgia for ordeal justice lingered. Astonishingly, the English Parliament did not formally abolish trial by combat until 1819. A trio of case studies illustrates how unpredictable medieval justice could be. Around 1020 in Old Saxony, a butcher's apprentice accused of stealing sausages submitted to the hot iron trial. His hand healed miraculously clean, perhaps thanks to a clever poultice or sheer luck, sparking a village feast in celebration of God's fairness. In 1258, a Slovak miller suspected of poisoning a pond faced the cold water test, floated like driftwood, and was declared guilty. As spectators dragged him toward execution, sympathetic neighbors cut his rope, fished him out, and convinced the Lord to commute the sentence to exile, a flash of mercy within the brutality. Fast forward to 1543 in Tecklenburg, Germany. Two merchants fought a judicial duel over a debt. The victor staggered away mortally wounded and died days later, rendering the legal victory pointless and prompting local counts to favor written contracts over dueling champions thereafter. Modern historians examining court rolls notice something fascinating. Ordeals often worked not because God actually intervened, but because psychology did. Guilty parties, terrified of facing boiling water or a skilled knight, frequently confessed at the last minute. Confession spared them agony and preserved communal belief in divine justice. In small societies, peer pressure amplified the effect. When an entire village expected God to expose wrongdoing, the weight of collective certainty could crush a guilty conscience long before a cauldron was heated. Echoes of medieval justice still linger in our language. The English word verdict derives from the Latin veredictum, a thing truly said, harking back to oath helpers swearing honesty. We still call any severe initiation a trial by fire. Journalists describe celebrities enduring public scandal as facing a trial by ordeal. Even the obsolete term compurgator, though absent from legal dictionaries, lives on whenever a character witness vouches for someone's integrity. Medieval justice may appear alien, searing iron, sacred pawns, and dueling knights, but the impulses driving it feel familiar. People wanted certainty in an uncertain world. They yearned for cosmic assurance that right would triumph and wrong would be exposed. Over centuries, Europe inched toward evidence-based courts, yet the old belief that divine or moral forces guarantee truth never entirely vanished. Next time you serve on a jury, remember that your role descends from those 12 oath helpers gathered around relics 1,000 years ago. So, which ordeal would you choose if you found yourself in 1198, the hot iron, the frigid pond, or the clash of steel at dawn? Let us know in the comments below. If this journey through the brutal and strange machinery of medieval justice intrigued you, hit the like button, subscribe to How Was History, and ring the bell so you never miss our next deep dive. Because the past may be gone, but its questions about guilt, truth, and the lengths we'll go to find them remain very much alive.